And you appear to be speaking and you're muted and we hadn't started yet. It's okay, we hadn't started yet.
Sorry.
That's fine. We'll start in just a
Okay.
You can't do anything we haven't done already ourselves.
May it please the court. I'm Bonnie Green, representing the appellant.
hang on, Ms. Green.
Okay.
We're gonna open. We'll open court and then I'll call the case and then we'll give you the
I understand. Okay, I understand.
The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has now resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. The next case is State versus Meader, and we'll hear from the appellant.
May it please the court. I'm Bonnie Green, representing the appellant, Ms. Meader, in this case. I'd like to reserve 5 minutes for rebuttal. The facts in this case show Ms. Meader showed up in a counseling center in Greensboro making a disturbance. The evidence shows she was really, really high at the time. One of the therapists called 911 about an intoxicated person. When the owner of the counseling center, Mr. Faulkner, arrived, he said her thinking was going in a lot of different directions. That was his testimony at trial. When the officers arrived, Ms. Meader pulled her pants down to show bruises and asked the officers to take pictures. She was so disoriented that she thought they were there to help her. She talked about getting beat up by a guy named Sebastian. She was so intoxicated that when the officers asked her to leave the counseling center, she said that she needed to get her bra from the bedroom, although there were no bedrooms in the counseling center. She was acting so bizarrely that she told Mr. Pinninger, the victim whose car was broken into, that she had been having sex with a bunch of people on a table, and they have a video of it, and a man jumped down 3 stories and punched her. This was very unusual behavior. She yelled, "I love you," several times when they put her in the police car. She was so intoxicated that she urinated in the police car, and her behavior was utterly unusual. Officer Fulp testified at trial that she, by first appearance, appeared intoxicated or impaired by an illegal substance. And one of the therapists, Ms. Sanchez, also testified that she appeared to be intoxicated. All of this conduct raises questions. Why would someone break into a car to steal a koozie, sunglasses, and an ammunition magazine? These were the 3 items for which she was convicted of 3 crimes: felony breaking and entering a motor vehicle, misdemeanor larceny, and misdemeanor possession of stolen goods. She was very confused about various objects. For example, her wallet. She said she needed to get her wallet, her bra, her purse. She asked at one point, "I'd like to get my purse," and her cell phone. At one point, she said, "I've lost my cell phone." This indicates that she was very confused about objects and items, which is inconsistent with someone stealing items like a koozie and sunglasses and the ammunition magazine. Why would someone do that? The answer is that she was very intoxicated or on drugs. It could be both. There is significant evidence that she didn't even know where she was. We should allow a jury to give the proper weight in a case like this. Her entire behavior is inconsistent with someone who had the capacity to form criminal intent to steal. Ms. Meader gave notice of her intention to raise the defense of voluntary intoxication. Her attorney also requested that instruction at trial. The trial court refused to give it. After hearing the evidence and being instructed on the law, the jury tried to do its job, but the jury struggled. The jury had a job here to determine whether Ms. Meader had the intent for the 3 crimes charged. The jury sent two questions during their deliberations. One was, we have an evenly split opinion on intent of the first two charges. What is our next step? The trial court instructed the jury to reach a unanimous decision. The next question the jury asked is, we would like more definition of utterly incapable. The trial court instructed the jury that those words have no significance in this case, although the district attorney used those words in his closing argument. Voluntary intoxication is not an excuse, but it is an affirmative defense the jury may consider in deciding whether Ms. Meader formed the intent required for each of the three crimes, which are each specific intent crimes. The burden of establishing the affirmative defense is to the satisfaction of the jury, not beyond a reasonable doubt and not by the greater weight of the evidence, but simply to the satisfaction of the jury. The standard, however,
I'm sorry, Ms. Green, I may be being confused here, but I thought the intoxication instruction would be to allow your client to argue that she didn't have the specific intent necessary for guilt of the crimes that she was charged with, not that it was an affirmative defense. Am I wrong about that?
Your Honor, my understanding is that it is an affirmative defense and that the trial court allowed her to argue anything regarding intoxication or intent at closing, but my understanding is that it's an affirmative defense that she raises and has to meet the standard for the trial court to instruct.
I mean, she has to, in order to get the instruction, I think she has to meet an initial burden of production, but assuming an instruction was given, it's not my understanding. My sense has always been that the burden of persuasion fell back on the state to establish beyond a reasonable doubt that your client had the specific intent necessary for guilt of breaking and entering a motor vehicle or larceny. Is that wrong?
No, Your Honor, you're absolutely correct. If what I said before was in disagreement with that, then I misspoke. That's absolutely
okay. I just want to make sure I'm following you, because I think the law is a little bit different on affirmative defenses and other, just denials of the existence of the elements of guilt.
Yes, I was reading from the Absher case, but you're absolutely correct. And if I misstated it, then I misspoke. The burden of persuasion always rests with the state, and it is a burden of production. The Court of Appeals error here was in not viewing the evidence in the light most favorable to Ms. Meader, as it is required to do, and the Court of Appeals repeated the error of the trial court in that sense. The Court of Appeals decision first relied on the fact that she wasn't arrested for intoxication. That fact is irrelevant to the inquiry. She was actually arrested for more serious crimes that required intent. The Court of Appeals also relied on testimony that she was, quote, fairly cooperative, unquote, which was Mr. Faulkner's statement. However, the testimony was conflicting in large degree on whether she was cooperative. There was testimony that she was disruptive and loud and would not leave when asked to do so by the therapist. She also did not leave when the officers asked her to leave. One question that arises is, will we take away her sole defense and punish her because one of the witnesses said she was cooperative? Furthermore, the Court of Appeals concluded that she was aware of and understood her surroundings. This repeated the error of the trial court. There was significant testimony that she was very confused about her surroundings. When she called her aunt from jail, she told her aunt that she had been arrested in High Point at Keith's house for blowing a horn, when in fact she was arrested in Greensboro. Again, she wanted to retrieve items from bedroom in the counseling center when there were no bedrooms in the counseling center. She was speaking to people who were not present. And Omar, she asked Omar to bring her wallet. It's incredible that the Court of Appeals and the trial court would conclude on this evidence that she was aware of and understood her surroundings. Furthermore, It's undisputed that she was intoxicated. The Court of Appeals acknowledged there was ample evidence of her intoxication at the time of the offenses charged. The trial court 3 times in the colloquy with defense counsel stated that there was evidence of her intoxication. The trial court even stated, "I understand that the witnesses in the light most favorable to the defendant have testified that the defendant was intoxicated." Further, the trial court said, "Certainly in this case, there was testimony that the defendant was intoxicated." The trial court's decision was based primarily on viewing body-worn camera footage from 2 of the officers who were there at the time. The trial court viewed this video and picked out certain aspects of the video, which ignored other evidence and failed to view the evidence in the light most favorable to her.
Even taking this evidence in the light most favorable to the defendant, counsel, in light of what the defendant has recognized that there is no evidence as to how much the defendant drank and over what period of time that she consumed whatever she drank or perhaps otherwise consumed, what weight should we give that?
Your Honor, I believe that is not determinative. So not a lot of weight should be given to that. I think that each case has to be decided on its merits. I acknowledge that there are a number of cases in which there is more significant evidence of intoxication. There is a case, State v. Cagle, that's cited in which the court said that evidence of the amount ingested and that the time over which it was ingested is not required. So I do not think it should be a per se evidentiary requirement, as the state has argued here. She is entitled not to testify. She chose not to testify. She's also entitled to rely on the evidence that the state presented under the case law, controlling case law. And it can't be that it's required for a defendant to submit a certain amount of evidence of the substance ingested or over what time. Witnesses can infer that she was intoxicated based on her behavior, and they did. Several testified to that. Even court itself acknowledged that.
Well, there are a few cases that have been cited. I'm hearing some background from somebody. I'm sorry if it's throwing me just a tad, but I'll plunge ahead. There are a few other cases on the appellate level. Getty, which is one that we have decided here at the Supreme Court. Court of Appeals has Wilson, Angeles, and Ash. All of them seem to be consistent that it was important that the defendant establish, in order to get the voluntary intoxication instruction, how long and how much the duration and the volume was of whatever the intoxicating substance was. How should we assess those cases in light of this case from a factual standpoint?
Yes, Your Honor. May I first start with the State versus Wilson Angeles? That case is particularly significant because the facts were so similar. In that case, the defendant was yelling profanities. She was acting bizarrely, singing hymns, claiming to be the victim, and even raising her shirt or pulling away her clothes to show an injury, which is coincidentally extremely close to the facts in this case. However, that case is distinguishable because there was much more evidence of her intent to commit the crime. She left the scene. This was an arson case. She left the scene to, also, I think it was murder, but involved arson. She left the scene to obtain supplies to form a Molotov cocktail. She threw the Molotov cocktail at the door, explained the desire to burn the victim out, and the court discussed that this preparation showed an ability to form intent. Furthermore, as law enforcement approached, she handed the container of alcoholic beverage to another person, which indicated her awareness and her intent to conceal her crimes. In State versus Getty, it was significant that the defendant shot the victim after he pleaded for his life 3 times, which also indicated an intent to commit the crime. I think in State versus Ash, similarly, the defendant left the murder scene, returned, drove the victim's car into a swamp, and then grabbed cash from the console before the car rolled into the swamp. In that case, one difference is that the cash has more value than the items in this case, which were a koozie, sunglasses, and an ammunition magazine, which, along with all the other facts in this case, raise significant questions as to whether she could form the intent. So I would ask the court to distinguish those cases on those significant factual grounds, or to, in its ruling, make clear that there is no per se evidentiary requirement for the amount ingested and over what period of time. And if I might, this leads me to just talk about the standard in general, the current standard. We have asked the court to correct that standard. A few things, the current standard is misleading, and it led to the error here. The standard uses the word utterly incapable. This is very imprecise language that has led to confusion over time. Someone cannot be utterly incapable. Someone is either capable or incapable. And that is a determination to be made by the jury after proper instruction. In terms of the precision of language, there can be degrees of intoxication. That is apparent.
Isn't this aspect of the argument the reverse of what the court decided in MASH? That it was appropriate to have the utterly incapable standard as a burden of persuasion, but not to instruct the jury that was the standard that it should use in determining whether the necessary showing of intent had been made?
Your Honor, could you rephrase the question? I'd like to make sure I answer it. I do know there are.
I'll be happy to give it another shot. At least as I reread MASH recently in preparing for argument, it appeared that they held, first of all, that the utterly incapable standard was the burden of production that the defendant had to make in order to obtain an intoxication instruction, but that assuming that the defendant satisfied that burden of production, that it was not proper to instruct the jury with respect to the utterly incapable standard, because one was a burden of production and the burden of persuasion was different. It seems to me that your argument is almost flipping that holding on its, is asking us to hold the exact reverse of what the court held in MASH. Is that right?
No, Your Honor, I would not be asking the court to hold the exact reverse.
Well, how do you square your argument with MASH then, which upheld the use of the incapable standard as the burden of production, but then said that it was not appropriate to instruct the jury in accordance with that standard?
Our argument is essentially that the utterly incapable standard is too high and is misleading. And the reason for that, I believe, is that it is archaic. In my mind, what has happened is that there is an underlying policy which is reasonable, which is to not have these instructions be given too much, to be cautious with the instructions. But the current standard is imprecise and confusing. And Your Honor, I think with regard to MASH, it was just a different situation. There, the district attorney had asked the court to instruct, to give the utterly incapable instruction to the jury. And I understand the case exactly the same way you do, that improperly shifted the burden from the state to the defendant to persuade the jury that the defendant was not utterly incapable, or that she was utterly incapable, I'm sorry. And that standard was too high. So I understand MASH exactly the same way you do, but if I don't think I'm asking the court to flip that burden. I'm asking the court to examine the way the standard is phrased. And if you compare it to diminished capacity instruction, that is much lower. I'm not asking the court to lower the standard to that level.
Well, of course, the case is just to differentiate in a sense between intoxication and diminished capacity as the result of mental difficulties. And the reason for that being that intoxication is a voluntary act, and you don't want to encourage people to, to drink and then, or otherwise impair themselves and then seek relief from liability for any criminal offenses that they might otherwise possess, whereas diminished capacity as a result of mental difficulty is something that the defendant really can't do anything about. And the cases seem to say, in effect, it's appropriate to require more in an instance in which the defendant's impairment is the result of his or her voluntary conduct as compared to something over which he or she has no control. Wouldn't making the two standards equivalent to each other run counter to that policy directive, which is maintained, which I think appears in our law pretty consistently?
Your Honor, absolutely. And as I've thought about this and preparing for oral argument, I have a suggested standard which is different from what was in the briefs, and I'm going to read it, and I'm happy to provide it later on.
Go ahead and tell me what it is now.
Okay. This would be the proposed standard. Whether there is substantial evidence that defendant was so intoxicated and as a result her mind and reason were so affected as to cause a reasonable doubt in the mind of a rational trier of fact as to whether the defendant was capable of forming the specific intent for the crime charged. And if you have another question, I will be happy to answer it. If not, okay. I'll just explain how I've arrived at that standard. First of all, as I mentioned, the word utterly is archaic. It's a word that we don't use a lot anymore in the law, and the word so is a simpler word that conveys a degree. And I absolutely agree, Your Honor, that I'm not asking this court to create the same standard as for diminished capacity. I do believe the law has a policy reason for having a higher degree in cases of voluntary intoxication. It is a voluntary act by the defendant, which impacts the ability to form intent. However, I think we can get away from the utter.
Let me ask you a real quick question. How would you explain the difference between the proposed standard you articulated and the standard for diminished capacity?
Your Honor, let me just get the standard for diminished capacity, which I think I have right here. If you'll just give me a moment. The diminished capacity instruction, thank you for your patience, Your Honor. The proper test is whether the evidence of defendant's mental condition is sufficient to cause a reasonable doubt in the mind of a rational trier of fact as to whether the defendant was capable of forming the specific intent. So that standard, Your Honor, just says, is the mental condition sufficient to cause a reasonable doubt in the mind of the rational trier of fact? The standard I'm proposing still leaves the trial court to look at intoxication, which I completely acknowledge is a standard of a degree. There is a degree of intoxication. All degrees are not the same. That's why I would suggest using the word so rather than utterly, which is simple, and allowing the trial judge to still consider how much evidence there is, not a per se evidentiary requirement, not how much was ingested over what period of time, but how was the defendant's mind and reason impacted. And that's what I consider what the defendant is arguing here in this case, is that her mind and reason were so completely intoxicated and overthrown. Also, the standard that I've proposed includes that language, mind and reason were so affected, because that is really what we are focusing on with intoxication, is that it's the mind and the reason. The diminished capacity instruction already incorporates mental condition as a what would the word be? It's just an inherent part of the mental condition that involves your mind and reason. But the standard I'm proposing is that there was substantial evidence that the defendant was so intoxicated, which is essentially the same as utterly, but it does not ask the trial court to find that the defendant was utterly incapable, which really is archaic, and it requires the trial court to make the ultimate decision as to intent, which should be the rational trier of fact decision.
Would you agree? Sorry about the echo. Would you agree that the standard you're proposing would require less evidence than a showing of utterly incapable?
Yes, Your Honor, I agree with that, because I think the current standard is so high that it requires the trial court to make a finding. And I also think the jury was, to answer your question, I think utterly incapable is an odd phrasing. Incapable goes to, if you look at the definition, capable means you're competent, able to do something. Incapable means you're not able to do something. And utterly incapable, it doesn't go together. You're either capable or you're not capable. But I think utterly should modify intoxicated, because utterly goes to a degree. I see that my time is, I only have a little bit of time left. So if Your Honors do not have any questions, I'd like to reserve the remaining time for rebuttal.
Thank you, counsel. We'll hear from the appellate.
Hello, may it please the court. My name is Matt Holloway. I will be arguing for the state in this matter. This court should affirm the Court of Appeals decision because the defendant has failed to establish that when she put the ammunition clip and the koozie in her pockets, when she hung the sunglasses from her shirt, that she was utterly incapable of intending to keep those items. The defendant is effectively asking this court to conclude that she produced substantial evidence that she consumed an intoxicating substance such that she rendered herself utterly incapable of forming that intent, yet she can only really point to an inference of intoxication born of testimony that she seemed intoxicated, the officer's testimony that she appeared either intoxicated or impaired by an illegal substance. There's a statement on the body cam video from Mr. Penninger that he smelled an odor of alcohol when he walked by her. And so we get an inference of intoxication. And from that, I think we get an inference that she consumed enough to render herself intoxicated. But she's unable to point to any further evidence about consumption. And I think that matters in this case because it limits the reasonableness of any inference that she consumed anything beyond the point of rendering her merely intoxicated. And mere intoxication is not sufficient to warrant an instruction. The defendant attempts to bolster her case by pointing to these bizarre behaviors. However,
let's talk about that a little bit, because your colleague has certainly pointed to some, shall we charitably say, unusual statements made by the defendant. What are we supposed to make of those statements? There's the evidence of them certainly in the record. Yes,
Judge. I think a a lot of the tension between what the state says about what the evidence shows and what the defendant says really centers on the evidence that relates to her control over her mental faculties. The defendant points to confusion about where she was, confusion about who she was there with, telling bizarre stories, changing her story. That evidence is all in the record. However, I don't think it stands in contradiction to other evidence that was considered by the lower courts, such that that evidence that was considered by the lower courts ought properly to be ignored. I think it's worth noting that we're not dealing with a kind of a simple fact like the color of a traffic light, where the defendant says it's green, the state says it's red. Those are obviously contradictory statements, and we can make that resolution. I think here we're dealing with the defendant's subjective mental state. And so I think confusion about where you are doesn't necessarily contradict evidence that you're aware of what's going on around you. And I think the evidence is very strong that the defendant was aware of what was going on around her.
I'm sorry, the audio is weird. How do you agree that we're supposed to take the evidence in the light most favorable to the defendant in trying to determine if she gets the instruction?
Yes, Your Honor. I think the evidence is to be taken in the light most favorable to the defendant. Contradictions resolved in her favor, reasonable inferences, but we don't get unreasonable inferences. And I don't think that countervailing evidence is ignored. I would suggest in State v. Long is instructive insofar as how this court evaluated the evidence. In that case, as here, the trial court denied the defendant's request for an instruction on voluntary intoxication. This court affirmed the trial court. The defendant lived with his mother, was convicted of murdering his mother. He was found drunk, nearly passed out in his bedroom in the home that they shared. His mother was found in the bathroom of that home. This court reasoned initially that there wasn't any evidence that he was intoxicated at the time of the murder. The court reasoned he could have become intoxicated in the intervening hours. And the court goes on to say that additionally, there is evidence that the defendant took steps to hide his participation in the crime. It points to him, the defendant, throwing a knife handle into a trash can. It points to him putting shoes under a cabinet, and it points to bloody jeans that were put in the sink and were wet, ostensibly to wash the blood off. But I think it's important to note that the record also showed that the trash can where the knife handle was thrown was in his bedroom. The shoes that he hid had left bloody footprints throughout the house that were not cleaned up. The jeans were in a sink that was in his bedroom. The evidence also showed he left a bloody shirt in his bedroom. And his mother's body was found on the floor. The knife blade to the handle that was in his bedroom was found under her body. There was blood on the walls in the hallway. And I think under the defendant's view of how to review the record evidence in the light most favorable to the defendant, I would suggest that the defendant would say that the reasoning and the inferences that were made in State v. Long was incorrect. I think what Long teaches is that
if that's correct, what does it mean to evaluate the evidence in the light most favorable to the defendant?
Well, Judge, again, I think we look at what evidence is or is not contradictory. And I think being confused about where you are doesn't contradict evidence that you're aware of your surroundings. If you're confused about what building you're in, it doesn't contradict that you're aware that the police are trying to get you to leave. It doesn't contradict evidence that the defendant resisted actively leaving. She wanted to stay at this outpatient mental health treatment facility. So I think, again, when we're talking about something as complex as the defendant's subjective mental state, it is not so. The categories of behavior and indicia related to her control over her mental faculties are not so clearly drawn, such that the evidence is appropriately characterized as contradictory and then wholly ignored.
Let me ask you a specific question about how to do that, taking it in the light most favorable to the defendant. And when I looked at the video, she is taking the thing out of her pocket. You referred to the items that she was charged with taking, and handed it to the officer thinking it was her cell phone. And then said something about, well, I wouldn't have given it to you if I knew it was a gun. And it was actually neither of those things. How do we look at that in the light most favorable to the defendant and its bearing on what she understood about the object?
Yes, Your Honor. Thank you. I think for that specific incident, I think leading up to it, the evidence would show that, the defendant says, "Oh, I've got a phone in my pocket," and then the officer responds, "Well, no, you told me you didn't have a phone," and the defendant pulls it out, and she begins to be arrested for taking the ammunition clip. And my read of what happens after is that the defendant says, I wouldn't have shown that to you if I had taken it. I wouldn't have taken it out of my pocket if I had taken it. And she's trying to, what I take that to mean, and what I would argue that means, is that that's a mind that is capable of forming the intent to keep an item that she's putting in her pocket, because she's arguing.
Well, why isn't it a reasonable interpretation in the light most favorable to the defendant that that interaction could signify that she had no idea what it was in her pocket?
Well, I think that's certainly, if it is interpreted as, if the inference is made, because I think that's what we're making, the inference is that she was unaware of what was in her pocket, and she didn't know that that's what she was being arrested for. I don't think that's what the evidence shows. And again, I think a lot of the tension about what the record shows focuses on the defendant's control, or, as the defendant argues, the lack of control over her mental faculties. One of the things that gets lost when we focus on that is the other evidence in the record that I think is properly considered. In large part, I think there is no contradiction about the defendant's control over her physical faculties. I think the evidence is very clear that she was not unsteady on her feet. She was simply not displaying any of the signs one would expect to see upon someone consuming so much alcohol that they were utterly incapable of forming specific intent. And I think this matters, because we're talking about the defendant's burden of production, of producing a substantial evidence. So evidence a reasonable mind would accept as adequate to support the conclusion that she consumed a sufficient quantity of intoxicating substances to render her utterly incapable. And in this case, I think a reasonable mind would not accept as adequate a mere inference that she consumed enough to become intoxicated.
Are you suggesting then that the outward signs of what might be considered to be associated with intoxication of some kind, such as stumbling, slurred speech, those aspects that were mentioned in the opinion, should carry more weight than the more mental aspects when it comes to the formation of a specific intent?
Thank you, Your Honor. I think that my sense from reading the case law is that these are very fact-intensive inquiries, very fact-specific, on the order of the questionable of reasonableness in a Fourth Amendment issue. But I don't know that there's a golden ticket. Again, I don't think the standard is that the defendant, and the state certainly isn't advocating for any per se evidentiary showing. I don't think the standard that it is that there needs to be certain showings in these categories. However, I think in this case, I think the defendant's control over her physical faculties ought be given greater weight because of the lack of any evidence of consumption. And I think that matters because when we're looking about the reasonableness of inferences that can be made about the defendant's consumption and the impact of that consumption on her ability to think and reason, when the defendant is essentially arguing, I drank so much, I was acting so out of my mind, people thought I was hallucinating, yet the only evidence that was caused by the consumption of alcohol is an inference. I think it becomes very unreasonable to make the inference that the defendant needs in light of the fact that she had displayed control over her physical faculties.
I asked opposing counsel earlier what significance, if any, in terms of weight should be given to the lack of any evidence as to how much was consumed and over what course of time was consumed. And her response was something akin to limited. What is your assessment as to how much weight the dearth of that kind of information should be given?
Yes, Your Honor. I think we'll try to answer your question. I think it depends. I think in this case, it is quite meaningful. Again, because of the evidence that I believe is properly considered about the awareness of her surroundings, the evidence about the control over her physical faculties, and the fact that we are here arguing about whether or not the defendant has established that her consumption of some intoxicating substance rendered her utterly incapable. And I think it's particularly meaningful that if we kind of, the idea is that we allow lay opinions of intoxication. This defense can be submitted without expert evidence or expert opinions about intoxication. There's kind of this background knowledge that we draw from that relates to what we expect to see when somebody drinks too much. And absent evidence of consumption, I think the defendant is limited in how far we can go with reasonable inferences about the meaning of these bizarre behaviors and whether or not they are frankly even relevant to the defense of voluntary intoxication. As was stated.
Can I go back to your basic assumption that there was no evidence of consumption, but I understood that there were witnesses who said there was one witness who said to the officers as they came up, they smelled the odor of alcohol on her, correct?
Yes, Your Honor. I think on the body cam footage, Mr. Penninger says, when I walked by the defendant, when he was, I think he was inside and he was leaving, he said, when I walked by the defendant, I smelled alcohol. He didn't do so.
That's evidence that she's entitled to rely on, right?
Yes, Judge. And I think, frankly, it's important evidence for the defendant because otherwise, I think we're looking at a statement that she seemed intoxicated. That was from the therapist. The statement wasn't that she was intoxicated. It was that she seemed intoxicated. The officer said she was either intoxicated. She appeared either intoxicated or impaired by an illegal substance. So we're still not really sure kind of what kind of impact we're looking for. And then when we have that statement about the odor, I think that gives rise to a reasonable inference that she consumed alcohol.
Right.
And I think I would hopefully try to make clearly is that even though we have an inference that she consumed alcohol, and then we have an inference that she consumed enough alcohol to render herself intoxicated, I don't think because there is not any evidence of consumption beyond that, I think it's unreasonable to make the way to consumption to the point of being utterly incapable. But yes, Your Honor, I do think that there was a statement about the odor that was on the body cam.
Would there be sufficient evidence? Oh, I'm sorry, go ahead, Justice Earl.
No,
I yield the floor.
I was just going to ask about the other evidence that all three of the videotape. So there's two body cam footage from one officer, a third video from a second officer, where she's seen, talking to people who aren't there. I mean, the jury saw all of those videotapes, right?
Yes, Your Honor.
And so I guess my question is, why isn't precisely this a jury question? In other words, why isn't it up to the jury to decide whether or not all of the evidence that is presented in the case, including the videotape of all the things that she did while the officers were there, why isn't it for them to decide whether she was intoxicated to the point that she couldn't form the requisite intent?
Judge, to be clear, are you asking about, I think my response would be to begin with the policies behind this defense and the threshold showing that needs to be made to the trial court. I think that the impact of this evidence must first be shown to be sufficient to support a conclusion that she was utterly incapable of forming specific intent. I don't think this evidence is appropriate for the jury to review because it doesn't meet that level. Again,
in this case that in the end, in this closing statement, the prosecutor did use that phrase, and the jury really was wrestling with what does utterly incapable mean, and how do we determine intent? That was clearly something that wouldn't it simply be, given the evidence that she was not acting rationally, smelled of alcohol. So I get it that there has to be a threshold showing substantial evidence that she was utterly incapable, but once that occurs, surely it's better for the jury to get the instruction than for them to be hearing all this and not have the instruction.
Yes, Your Honor. Well, I think in this case, the jury was instructed on the meaning of utterly incapable. When they submitted the question, the judge brought the jury back out and said these words have no legal effect or impact in this case. That instruction was given without objection. And I think the jury is presumed to follow that instruction. Additionally, I think the prosecutor was responding to arguments that the defendant had made, the defense trial counsel had made, about the impact on her intent of her alleged intoxication, or that, as the evidence showed at the trial, the defense attorney was arguing that she was too intoxicated to know what she was doing. I think the jury received a full airing of this argument that was appropriate on this evidence. I think certainly I can imagine that the prosecutor, if he could take back 2 words, he would take back utterly incapable. But I think the trial court responded appropriately to the questions, provided instructive guidance to the jury. And I think, if anything, the questions, they are questions. I don't know that they represent confusion by the jury. I think they represent a jury being deliberate and considering all the evidence according to the law. And the law that was given was, if you have a reasonable doubt about the defendant's ability to form the specific intent to keep what she took, you need to find her not guilty. And again, so I think really the defendant received a fair and full airing of this question. I would acknowledge that jury instructions are important, but in this particular case, on these facts, as we argued in our brief, I think the question was properly presented to the jury in a manner that was not confusing or prejudicial to her. So really, at the end of the day, the defendant can point to kind of inferences of intoxication, inferences of consumption, and a series of bizarre behaviors. And as in regard to the meaning of those bizarre behaviors, I think we're limited in the inferences that we can make about what they mean as evidence of the impact of the defendant's consumption of intoxicating substances, because there is such little evidence of consumption, and because of the control she exhibits over her physical faculties. Additionally, I think, as was reasoned, certainly I would say it was dicta in State v. Gerald, but in that case, the defendant had argued evidence of his hallucination and his mind coming and going, and that he flipped out, was evidence, the defendant argued, of his, he was so intoxicated he couldn't form specific intent. This court noted that, well, actually, that kind of evidence is more relevant, more appropriate to the defense of insanity. I would suggest
is there sufficient evidence in this case to support a diminished capacity instruction?
Well, Judge, the defendant sought a diminished capacity instruction at the trial level. It was denied, and that issue wasn't preserved. But I think certainly in terms of what this evidence means for a voluntary intoxication instruction, I think some of this evidence is more appropriate to a mental health-based defense. And so at the end of the day, I think that we would really argue that because of what was properly considered by the court, again, I think she did display an awareness of what was going on around her. She sees police officers. She says, "I've been the victim of abuse. I have evidence. Take a picture of this evidence. Preserve this evidence." That is a mind that is thinking critically and trying to engage with her surroundings and is aware of what's going on. Insofar as that she's confused about where she is, she knows that she's being let out of the building. And while she might be confused about what she has in the building, she knows that she's not going to be coming back, and she wants to take her things with her. That is a mind that is capable of forming specific intent. Again, it's not that the defendant needs to have the ability to form specific intent for the hour before the crime and during the crime and the hour after. It's just when she takes those items, puts them in her pocket, hangs the glasses from her shirt, and leaves the car, she's intending to keep those items. And I think the record is replete with evidence that she could do that. I think the impact of the defendant's consumption is not supported by substantial evidence. And I think the lack of the production of consumption and the evidence of the physical control she displayed limit the reasonableness of inferences that could be made about her consumption. I don't think, when we're talking about the production of substantial evidence, I don't think a reasonable mind would accept the absence of evidence as adequate to support the conclusions that the defendant wants. The state would ask this court to decline the defendant's invitation to jump from these inferences all the way to the conclusion that she consumed a sufficient quantity of an intoxicating substance to render herself utterly incapable of forming specific intent. This is a defense that is dangerous in its application, been described as dangerous in its application. The public policies behind that are very clear. And in close cases, it shouldn't be applied. Not to imply that the state would suggest this is a close case, but certainly I think the fact that we're arguing before this court is some indication of that. The facts are odd. However, I don't think that the bizarre behavior, even in light of being intoxicated, reached the high bar of establishing that the defendant was utterly incapable. And for these reasons, the state would ask that this court affirm the lower courts. If there are any questions, I'm happy to answer them in my remaining time. Otherwise, the state would rest on its briefs.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. Several points just to make quickly in rebuttal. Mr. Holloway, my friend Mr. Holloway, talked about the physical faculties. I would just point out that Ms. Meader urinated in the police car. This demonstrates a lack of control of her physical functions. But importantly, the current standard focuses on mind and reason. That is the way the legal standard is phrased, and the focus should be on the facts that relate to her mind and reason. The control or not of physical faculties is a factor, but it is not determinative. I do agree with Mr. Holloway that this is a very fact-intensive case, as we have discussed, and the evidence must be viewed in the light most favorable to Ms. Meader. With respect to what happened, how Ms. Meader characterized the ammunition magazine, she did say that it was a gun, and on the video, one of the officers can be heard saying it wasn't a gun, but she might think it was a gun, which is further evidence that the people present at the scene at that moment were aware that her understanding of what objects were that she had or did not have was not appropriate or in line with someone who has control of their mind and reason and knows what's going on. Just with regard to the transcript, there are multiple places where it is characterized differently, that this was called an altercation. Someone referred to it as an altercation. So there's significant evidence, and I just ask that the court would view that in the light most favorable to her as required. And everyone did agree that she was intoxicated. She's not asking for a non-suit here. She is just asking that this court hold that she's entitled to a new trial because the evidence of intoxication was so great that the jury should have been instructed. Her lawyer did file a motion to dismiss. That was not raised on appeal. Again, we are not asking for a non-suit, merely asking that she be given a fair trial free of prejudice. Jury instructions are very important. This court has held that they are critical in criminal cases. The jury was denied this explanation and denied this opportunity to understand how to do its job. The question of moral culpability was close in this case. Intent was central. Ms. Meader is entitled to a new trial free of prejudice and requests that the court reverse and order a new trial. Thank you.
Thank you, counsel. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court.